You are under arrest. Before we ask you any questions, you must understand what your rights are. You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to talk to a lawyer for advice before we question you. If you cannot afford a lawyer and want one, a lawyer will be provided for you. These are the rights that every citizen has. Each lawbreaker you see here was arrested for a crime. Then why, out of thousands of kidnappings and rapes that had come before, would Ernesto Miranda's case be decided by the Supreme Court and affect every arrest in the United States from that day forward, and come to be the case that changed American justice? The Miranda Act was far from the only significant event of 1963. The development and testing of nuclear weapons by the United States and other nations created the problem of radiation fallout, which threatened to poison the Earth. On August 5, 1963, the Nuclear Test Ban Treaty was signed in Moscow by the United States, the Soviet Union, and Great Britain. More than 100 other governments signed the treaty in the next few months. And on August 28, 1963, Martin Luther King Jr. was the principal speaker at a civil rights march on Washington, D.C. His eloquent I Have a Dream address was the high point of the demonstration. Also during that year, in the presidential jet in Dallas, Texas, Lyndon B. Johnson took the oath of office on November 22, 1963, after the assassination of President John F. Kennedy. By Johnson's side were his wife Lady Bird and Mrs. John F. Kennedy. 18-year-old Rebecca Ann Johnson was raped on March 2, 1963, by a man later identified as Ernesto Miranda. After his arrest, Ernesto Miranda soon made a written confession to the rape of Rebecca. The conflict in this case was the fact that he was not read his rights at the time of interrogation by the two police officers, Carl Cooley and Wilfred Young. Miranda, as a citizen, had the constitutional rights to not incriminate himself and to consult with a lawyer. He had signed a statement that he understood his rights, even though they weren't made clear to him. His written confession would be subject to debate all the way up to the United States Supreme Court. This small inner-city case was soon to become an enormous national conflict between law enforcers and lawbreakers. The Arizona Superior Court found that the U.S. Supreme Court's unpopular Escobedo decision did not apply to Miranda. Arizona Superior Court Justice Ernest W. McFarland centered his decision on the fact that Miranda had not requested a lawyer at the time of his arrest and therefore was not entitled to the protections offered by the Escobedo decision. After Miranda was sentenced to 20 to 30 years in prison by the Court of Arizona, Alvin Moore, his lawyer, appealed the case to the Arizona Superior Court. He believed that McFate, the judge, had made an error when he allowed the confession to be entered, and he felt that without it, Miranda would have beaten the charge. This case was compared to the case Escobedo versus Illinois. In the Escobedo case, the court ruled that when police are no longer conducting a general questioning into an unsolved crime, but are focusing on a particular suspect in custody, refusing to allow the suspect to consult with an attorney, and failing to warn the suspect of his right to remain silent is in denial of assistance of counsel in violation of the Sixth Amendment. Miranda was to spend 20 to 30 years for both crimes he was charged for. Do you think the Supreme Court's decision to dispose of Miranda's sentences was the right thing to do?
I think the evidence against Miranda was pretty clear that he was guilty. So by reducing the sentence or commuting the sentence, I think it was maybe an injustice. I think we have too many people in the society today that are victims or think they're victims. And I think we spend too much time worrying about the rights of the accused and maybe not so much about the responsibility of the perpetrator.
Ernesto Miranda had spent 2 years in a prison near Florence, Arizona. Miranda had submitted a request for a review of his case to the U.S. Supreme Court in June 1965 because he knew the Arizona justice system had done him wrong. The American Civil Liberties Union was looking for a case to take to the Supreme Court to get some clarification on the Escobedo decision. Don J. Flynn and his partner, John P. Frank, agreed to take Miranda's case. Flynn and Frank submitted a 2,500-word argument to send to the U.S. Supreme Court to review Miranda's case. They decided to base their appeal on the Fifth Amendment rather than the Sixth Amendment. In November 1965, the 9 justices decided to answer the pleas for help from the federal and state courts that were struggling with the Escobedo decision. The case that the justices decided to take was Miranda versus Arizona. In February 1966, the 9 justices heard the oral arguments in the case of Miranda versus Arizona. Flynn argued the case for Miranda. John Flynn outlined the background of the case against Ernesto Miranda, recounting the assault, the arrest, trial, and conviction. He pointed out that Ernesto Miranda had not been advised of his right to remain silent when he had been arrested and questioned, adding the Fifth Amendment argument to his case. He went on to say that a man like Miranda, who wasn't rich, who was emotionally disturbed, who had a limited education, shouldn't be expected to know his Fifth Amendment right not to incriminate himself. Gary Nelson spoke for the people of Arizona, arguing that this was not a Fifth Amendment issue, but merely a vehicle for the court to expand its Sixth Amendment Escobedo decision. A second day of oral arguments followed on March 1st. That day, the justices honed in on the Fifth Amendment aspects of the case, which pleased John Flynn to no end. The last man to present a position in the case before the court was Thurgood Marshall, whose personal opinions were diametrically opposed to the position of the U.S. government. John Flynn and John Frank were Miranda's two lawyers at the Supreme Court hearing. Their idea was to base their arguments around the Fifth Amendment instead of the Sixth Amendment. Do you think they would have still won the case if they did the opposite?
I really do, because I don't think the Founding Fathers intended for there to be a big difference between the Fifth and Sixth Amendments. They both have to do with due process of law, or the rights of accused people. To me, the Sixth Amendment has always just been a continuation of the Fifth Amendment.
After deliberation, the justices issued a written opinion. After 4 months, Flynn, Frank, and especially Ernesto Miranda won hands down. From this point on, the court decision required law enforcement officials to ensure that detainees have been briefed on and understand their constitutional rights. Police departments around the country started to inform suspects they have the right to remain silent. Anything they say can and will be used against them, that they have the right to an attorney, and if they cannot afford an attorney, one will be provided free of charge. Ironically, after his release during one night in January 1976, Miranda played a part in a poker game. A fight erupted, and he was stabbed to death by an illegal Mexican immigrant. He died at 34 years old. In the wake of the Miranda Act, confession rates across the nation declined drastically. Each year, roughly 30,000 criminals and 90,000 property offenders for FBI index crimes are set free. In addition, prosecutors lose cases against 62,000 drunk drivers, 46,000 drug dealers and users, and several hundred thousand other criminals due to improperly Mirandized suspects. This was indeed a case that changed American justice. How did you and other officers react when the Miranda Act was passed?
When it was first announced, we felt like it was giving the criminal all the benefits and taking away from us. But once you give them the Miranda rights, as it was originally written, you expect them to shut up.
Today, the Supreme Court is in the center of a decision that will determine whether decades of restraints on police interrogations should be discarded. In the case, U.S. v. Payton, Samuel Francis Payton was arrested by the Colorado Springs police for violating a court order to stay away from his ex-girlfriend. Officers got as far as the right to remain silent when Payton told them he knew his rights and didn't need to hear the rest. He told police they could find a pistol on the shelf in his house. The finding of the gun led to a federal indictment of Payton. The Supreme Court announced that it will review this case, which could help further define the Miranda ruling. How did you think this affected the way law enforcement worked?
It tied our hands, especially when it first came into effect. And once everybody got used to it, it was a little better.
Did this complicate your job in any way?
Oh yeah. You know, a lot of times you put somebody in jail and they're out on bottom before you finish the paperwork.
Law enforcement officers are faced with a difficult task on a daily basis. They have the responsibility to protect the citizens while respecting their rights. As the Supreme Court deliberates on the most current Miranda challenge, we must never lose sight of the fact that the Bill of Rights is the sole key to the free people of America and the future of our nation.